Autumn would love to introduce you to Scale IP, the world's fastest growing IP commercialization software. Are you ready to transform your tech transfer office into a marketing powerhouse? Using proprietary IP transaction data, Scale IP helps you easily find high-intent companies that partner or license with universities, gain technical fit insights, and launch personalized email campaigns with the right IP decision makers to save time, money, and effort. Don't let your innovations get lost in the shuffle. Right now, you can get a buy one, get one free offer when you sign up with promo code AutumnLove1 at www.scaleip.com. That's Autumn, Love, the number 1 at www.scaleip.com.
You're listening to Autumn on the Air, the weekly podcast that brings you conversations about the impact of research commercialization and the people who make it happen. Join us for interviews with patent and licensing professionals, innovators, entrepreneurs, and tech transfer leaders on the issues and trends that matter most. Keep listening for an inside track on the people, IP policies, and politics changing our world.
In recent years, CRISPR technology has emerged as a game changer in the world of gene editing, unlocking remarkable possibilities across various sectors, including healthcare, agriculture, and environmental science. But what is CRISPR? CRISPR stands for Clustered Regularly Interspaced Short Palindromic Repeats and is based on the ancient function of prokaryotes, single-celled organisms such as bacteria. Bacteria deploy a specialized CRISPR-associated molecule known as Cas to cut and destroy the DNA of invading viruses called bacteriophages. The CRISPR-Cas system has been engineered to work in eukaryotes like animals and plants. Its ability to make precise, targeted cuts in DNA sequences allows scientists to insert, delete, and modify DNA sequences of a variety of cells. Various Cas proteins have been identified. The best known is CRISPR-Cas9, which has become a transformative tool in genome editing. Given the potential value of this transformative technology, the CRISPR patent landscape is vast. Some estimates suggest that there are more than 12,000 families of patents on CRISPR-related technology. Given this, it's not surprising that disputes have arisen over the ownership of patents relating to CRISPR. Most famously, two groups have claimed rights to use the CRISPR-Cas9 for eukaryotic gene editing. The University of California at Berkeley, University of Vienna, and Dr. Emmanuel Carpentier, collectively known as CVC, on one side, and the Harvard-MIT Broad Institute, known as the Broad Institute, on the other side. This dispute has resulted in several complex and lengthy disputes at the U.S. Patent and Trademark Office, the European Patent and Trademark Office, the Japanese Patent Office, and the Chinese Patent Office, as well as in various courts in which the proceedings are still ongoing. Here to help us understand the latest in these ongoing disputes is Dr. Kevin Noonan. Kevin is an experienced patent lawyer, molecular biologist, and renowned thought leader in biotechnology and pharmaceutical patent law. Kevin is a partner at the intellectual property law firm McDonald, Bainan, Hubert, and Berghoff, where he is co-chair of the firm's Biotechnology and Pharmaceuticals Practice Group. He is also the co-founder of and regular contributor to Patent Docs, a website featuring news and commentary on patent law, a co-editor and contributing author of the book, Claim Construction and the Federal Circuit, and a contributing author of Antitrust Issues in Intellectual Property Law, now in its second edition. Welcome, Kevin. Really excited to have you on the podcast today.
Yeah, this should be fun. I'm looking forward to it.
Yeah, and we have a lot to talk about today. There is a lot of subject matter here to cover. So I thought maybe, Kevin, the best way to get things started today is to ask you how the Broad Institute and CVC came to be key players in the CRISPR patent landscape. And in fact, for those who may not be familiar, if you could explain which party filed on what and when, I think that would be really helpful.
Sure. This was one of those situations. There are two ways an interference can be declared, one where the patent office does it, and the other where somebody provokes an interference. And we'll talk a little bit more about that in a minute. But the first one came because the Broad had very aggressively filed lots of patents on fast track or whatever the name for it back then was. And so they amassed a fairly solid actual patent portfolio, not just applications. Whereas CVC, which is University of California, Berkeley, the University of Vienna, and Emmanuelle Charpentier, who kept the rights to her patent, I get her interest in the patents independently. So they took a more traditional approach that in retrospect was a little bit more lackadaisical than it needed to be. They just filed their application and waited for the patent office to do what it does, which meant that when they, meaning California, got close to having something that was allowable, where the patent office was willing to grant them a patent, the patent office does what it does. It looks to see, are there anything out there that's interfering subject matter? And all these Broad patents came up, and voila, declared the first interference. And so you had all of these Broad patents, and you had the application, and maybe some applications as well. And you had the California, I'll call them just California, application. And that was the first interference, the 048 interference that was declared almost 10 years ago, between the parties. And the senior party in an interference is the person who gets all the presumptions. That was the Broad, mostly because it had the earlier filing date. It had filed its patent. Now remember, interferences only happen in the first to invent regime. So the fact you have your earliest filing date doesn't mean you win, but it does mean presumptively, if there's a 50-50 flip of the coin, you get the presumption in your favor. So being a senior party is important. And I mention that only because it's relevant to other things we'll talk about later. So that was the first interference that was declared between a bunch of patents and applications by Broad. And I think it was just that one application by California.
Yeah, and you've mentioned interferences, and there were 2 interferences declared, and we don't really hear much about interferences anymore. As you mentioned, it's something that happened and was declared in the first to invent system, and now we're first to file as a result of the Americas Invents Act. So given that, for people who may not be familiar with interferences, can you explain a little bit about what they are?
Sure. And I've done a bunch, and they're a lot of fun. I'm sad to see them go. But the way it works is, no matter how they are initiated, and it doesn't matter which one, you get a declaration of interference. And declaration of interference identifies the parties, say who the senior party and the junior party are, and produce what's called a count. A count isn't a claim, but it looks like one. And in some instances, as in this, both interferences between California and the Broad, you had essentially a claim from each party. So it was this or that sort of a thing. And they tend to be the same subject matter. It's just they may be worded slightly differently. It's a way that you don't get into a lot of tedious and time wasting back and forth as to what terminology you should use. Well, the first thing that happens is you have what's called it's sort of a motions phase. And you have the ability to file a bunch of motions. If you want, you can change the count. You can change what patents or applications correspond to the count. You can change, you can say whether there really shouldn't be an interference in the first place, and things of that nature. And all of this is done under circumstances where you have filed your priority statement with the patent office, which is the first evidence you have of conception. Not reduction of practice, just conception. And it has to be, actual evidence, documentary usually. In this case, there was a laboratory notebook page that California submitted. But none of that is made public at that point. You get that. Now, it used to be, back in the old days, interferences could go on forever. But in about 2004, the patent office changed its interference rules just in time for them to go away. But the amount of the parties can agree amongst themselves to get extensions because, as you might imagine, you have motions and you have oppositions and you have replies. They get to do all of that, except there are 3 dates that are written in stone, one of which is the date of final hearing, and there's a few dates before that that are relevant to that. And that's unless the board decides that's when you have to be ready for final hearing. All your briefs filed, all your evidence submitted and annotated and all of that. So that means it usually takes, I'm trying to remember back, maybe it was 9 months or so, maybe a little bit more. That happens. And then the board, at its leisure, but they're encouraged not to dilly-dally, they rule on all those motions. And sometimes the other patents, if I want to get one of your patents or applications to correspond to the count, I give you the evidence of why. They could decide to do that or not. If I want to get some of my patents taken out of the count, same reason. If I want to change the count, all those things. And then that's that. Then you have the priority phase. And the priority phase is when, number one, the party's declaration of priority, what their evidence is now open, is shared. It also becomes public. And then you have the evidentiary phase in the sense that you can depose the inventors. You can proffer expert witnesses. You can do that sort of thing. That essentially is meant to get all the evidence that the parties want the board to consider as to whether or not they deserve priority, and that also includes, of course, attacking the priority date that you get as either a senior or a junior party. You can also actually ask the board to switch who is senior and who is junior party. Usually that's before the priority phase, but regardless, you can do that sort of thing, and then you get the final briefs and final hearing. And that's when, and this is all, of course, available online, and you can listen to it if you're interested. But that's where you get the final decision, ultimately by the patent office, by the board, which can be appealed to the federal circuit. And so that's where we in both cases that happened. The board made a decision, and it was appealed to the federal circuit.
Yeah, and usually interference is right between a patent and a pending application, or two pending applications, correct?
Yeah, there are ways that you can have this priority fight over patents, both patents, but that's under statute, but that's in court. And that's where you literally have to get a court to decide. In this case, it was patents and applications. You can have two applications. Again, if you want to get into the minutia, in the past, what would happen is you'd have your patent application going on, and you think you're going to get an allowance, and you'd get a note from the patent office that your claims are in condition for allowance. However, somebody else is prosecuting claims for which we think there's interfering subject matter, and we're going to wait for you to get your patent until we decide, right? And I don't think none of that happened here, but the point is the patent office did back in the day. They would have a function where they would just monitor what was going on. Once you were in condition of allowance, then they would look to see, does anybody else have any patents or applications that could be interfering? Then they would do their internal determination whether they should declare an interference. And that's when you'd get to the point where the declaration was issued.
So turning now to the first interference, can you summarize at maybe a high level what exactly the main claims and inventions were in that interference?
Well, it was the same thing in terms of the California claims had been just not limited to cell type at all. Basically, it was CRISPR. There was no limitation cited in their claims as a prokaryotic, eukaryotic, whereas the Broad laser focused on eukaryotic cells. And so they both had claims to CRISPR. One was narrower. I mean, remember, first year patent law, I invent a television, you invent a color television. Who has priority for that? I mean, we've all heard that analogy. Similarly here, the California people had invented CRISPR, full stop, whereas the Broad people had invented eukaryotic CRISPR. And that was the board in determining what claims were involved and what the count was, didn't make a determination as to any limitation on that basis. And so it was pretty much everything that the parties had related to CRISPR at that time. I'm not sure. There might have been one or a few pending applications that weren't joined, but nothing else.
Yeah, and what was really interesting then was the Patent Trial and Appeal Board, also known as PTAB, they dismissed that first interference, finding no interference in fact. So what does that mean when there's a finding of no interference in fact? And then what happened to the case from there?
Okay, well, what happened in that case, it's a good example. What happens is that the Patent Office has made a determination that there's an interference. And so then what Broad did, it filed a motion that there was no interference in fact. And it said, Patent Office, here's the standard. The way you figure out whether there's interference in the first place is you say, I'm going to take one party's disclosure and claims. I'm going to pretend that's in the prior art. And then I'm going to look at the other party's claims and say, if that was in the prior art, would that invalidate either beyond anticipation or obviousness? And then you do vice versa. Right? And what Broad was able to successfully argue was that the complexity of eukaryotic cells meant that the fact that CVC was able to show CRISPR, mostly in bacterial contexts, the fact they were able to do that meant that their eukaryotic cell CRISPR was not obvious, because there would be no reasonable expectation of success that you could in fact do that. That color television analogy is apt here, so that their admittedly more limited claims only to eukaryotic cell CRISPR, those claims should be patently distinct from the broader claims that CVC had gotten, and therefore they shouldn't have interference at all. And that was, the board decided they were right, and the Federal Circuit reviewed that and decided they were right, to tell you the truth. I think a lot of that came from the fact that under the Zerko case, a lot of that, as we all know, obviousness is a legal question that has underlying factual issues. I think because the Patent Office had determined as matters of fact what these consequences of the differences between the cell types were, it was always a very difficult path for California to take to overcome that. And so it wasn't, I think, very surprising when the Federal Circuit affirmed. And then there was no interference in fact, which meant that none of Broad's patent estate was at risk. And also that California could get its unlimited CRISPR in any cell type claims, which they did.
Yeah, so very, very interesting in that first interference. So interference number one, victory to Broad, and that takes us to the second interference. So what was the subject matter there of the claims and inventions involved in that particular interference?
Well, it's interesting because California made a decision, and I say this when I talk about this topic, and people don't always agree with me, but I'm going to say it now. They were sitting, I think, in the same position as the television set guy, vis-a-vis the color television set, because they had a dominating claim. Their claim was not limited, and the fact that there was no interference in fact didn't change that, because that typically is what happens when you have a broad claim and a narrower species claim. It happens all the time. And so that wasn't a problem, but we can speculate as to the reasons, but California wasn't happy with that. And so they actually provoked an interference by filing claims specifically directed at eukaryotic CRISPR. And intentionally, they asked the Patent Office, you should declare this interference because this is the right interference that you should have declared in the first place. We think you were wrong about that interference in fact, but let's make it perfectly clear. And so that's what they did. And they, at that point, had filed a bunch of applications. They didn't just have that one, because that one grants us a patent, but they had continuations and divisionals and all of that on that patent. And they had quite a few. I have a chart somewhere. It's maybe 13 or something. But the fact is they had a bunch. And now, of course, Broad had its bunch of patents plus applications. And so in terms of the subject matter, the number of patents at issue, there were more in the second interference than there were in the first.
So, and then the PTAB held for Broad. And can you share a little bit about the rationale in that decision? And then what happened?
I'll tell you, without tooting my own horn, go on the patentdocs.org blog, because it's a story. It is a story, let me tell you. So two things happened. The first thing that happened is that Broad asserted that they had gotten dual guide RNA CRISPR. Right, there are two RNAs associated with the Cas9 protein. One, the CRISPR RNA, that's specific for the site where you want it to be cleaved, and the other, the tracer RNA, which is something that's more of a structural RNA that keeps everything in the right place as it gets done. They have priority back to that. The second interference, though, was limited to single guide RNA, in which those two pieces of RNA are linked. They have a small, 10 nucleotide or so linker. Okay, and that's what both of them did in eukaryotic CRISPR, in their patents and their claims in this one. But it seems that if you look at the priority document at the priority evidence for California, they have a laboratory notebook where they have that all laid out, and that's fine. Well, there was a Professor Marafini from I think the Rockefeller, and he was at a talk where Jennifer Doudna talked about that, and he called up the Broad people and told them about it, and kind of he told them on someday in June, and very shortly thereafter, all of a sudden, that's exactly what they were doing. So that, I'm not going to cast aspersions, but that's the facts, okay? And you can take that what you will. But also what happened is then, as I said, Broad was laser focused on getting this done and did it did it in kind of the same time frame, a little bit more quickly than California did. They were a little bit more academic, if you will, sort of having graduate students do it and things like that. And I was a graduate student at once, so no offense to graduate students, but they didn't have that commercial competitive sort of attitude. It didn't appear to anyway. And so it took them longer. And the Broad was able to successfully argue to the board that a length of time, which was like less than 6 months. So let's get perspective here. If anybody's ever been to the bench getting something to work like this, less than 6 months is a triumph. But the fact is they were able to convince the board that showed insufficient conception. That showed that their conception in March wasn't conception, that because they had to do all of these experiments to actually get it to work, and the Broad had argued earlier that this should be an old conception and reduction to practice standard. That back in the day with DNA, for example, that's what a lot of people would argue. Simultaneous conception reduction to practice, exactly. Well, they kind of argued that and they let it go by the wayside. They didn't need to. They were able to show, and they had a very nice slide to show it, all of their successes all through the summer of 2012 and all of the failures by California wasn't helped by lots of evidence from emails and texts and stuff from Professor Doudna and others about how much trouble they were having. And it convinced the board that, the fact that they themselves said they were having trouble. They themselves said, we're not sure we're going to get this to work in eukaryotic cells. There was all that evidence. And so they convinced the board that even though technically the evidence of conception was in March, which is 3 months earlier than the best conception date of June, when they actually got it to work. Broad, I mean, that Broad should get priority, and there were lots of motions made about the shenanigans, for want of a better term, of the professor telling them about it, but Jennifer disclosed it in open forum. So there wasn't anything underhanded, and there was no reason that he shouldn't tell them about it. So again, but all that went by the wayside, and it just came down to that argument that clearly, and remember, the board had determined in the first interference that this was complicated. This was so complicated, and so this was consistent with that determination that in something this complicated, if you couldn't get it to work, it meant you didn't really have conception, because in a complicated system, there were things that you had to know and do, and you didn't know them, because if you did, you would have gotten it to work earlier. So that was the basis for why they won. And that's the determination, the decision that's up before the Federal Circuit now. And they had it on May 7th, and it's now after October 7th. So do the math. That's quite a while. So I think they're probably struggling with it. All I will say, what surprised me, and this is also on the Federal Circuit website, is if you want to listen to the oral argument, interestingly, I think that the judges really seem to be a lot more skeptical about the Patent Office's decision than I expected them to be. Because remember, this, as I said before, this was in this case, you had a facts dispute, because a lot of these things were factually determined. And the Patent Office had made a factual determination for which, under Zerko, they deserve to get deference. And that, I mean, if you read almost any Federal Circuit opinion, anytime there's a factual question, it's almost pro forma. I won't say it's a rubber stamp, but it's very hard for the losing party to argue that the Patent Office got it wrong. But these judges, a couple of them at least, seemed to resonate that with what California said, which was it was a misapplication of the law. That wasn't the facts that was the problem, is that given the facts that the PTAB didn't apply the law properly, and it seemed to resonate with the judges. So at some point, this is going to come down. And the other thing I wanted to say is that frequently a second conceiver, because there was no question that the March notebook from Jennifer Doudna's lab was the first conception on paper. But the first conceiver is presumed to be the person who deserves the invention. But one of the few circumstances in which the second to conceive gets to be the inventor is that the first to conceive doesn't show diligence, doesn't show that they work diligently to get to the actual reduction of practice or filing a patent application, constructive reduction of practice. But there was none of that here. Clearly, the evidence, although of unsuccessful attempts to reduce the practice, there was no question that they weren't trying their hardest to do it. So that wasn't the issue. So this is really an anomaly in interference law to have the second to conceive, in the absence of these diligence issues, to have the second to conceive get the priority. And so maybe, speculating, that's the reason why it's taking the Federal Circuit as long as it is to come to a decision.
Yeah, because that oral argument, as you mentioned, was in May, and here we are in middle of October and still no decision. Kevin, any predictions on how you think they're going to rule?
I don't have. I can predict this. No matter who wins, any cert petition to the Supreme Court will be denied.
I could have predicted that too. Yeah,
it's not even worth putting it on paper. It's just not gonna. It's not gonna happen. But no, I think that if I were Broad, I would not be happy about the state of affairs. I think that the likelihood is that my prediction, they're going to vacate and remand. Right? They're going to say, we're not comfortable with the way the law was applied. Maybe there's a fact issue or two they're not comfortable with. We don't necessarily think you did this right, but we're not going to reverse. We're not, because I'm sure California wants to reverse. We're not going to reverse, of course. But what we're going to do is we're going to give you a do-over. We're going to take a mulligan for the golfers in the audience. So you're going to be able to look at this again. We're going to tell you how we think you should apply interference law on conception and priority. This is what we think the law says. So it's going to be no possibility of misunderstanding the second time around. So we're not going to tell you what conclusion you should come to. We are going to tell you this is what the law says and how you should apply it. Now, go back, look at the facts, and determine whether, do you apply it the way we told you to. The only question will be whether, when it goes back, whether the board says, we want briefing from the parties on this. Which they might, and if they're gluttons for punishment. And so, and if they do, then it'll take even longer than it will take when the Federal Circuit finally comes down for its decision now.
Yeah, and then we're going to be talking about this again in a couple of years because it'll make its way through the board, back up to the Federal Circuit, and yeah, it's going to take a while if that's the result.
Yeah, I guess I want to remind people that the priority date for this was in 2013. So, I tell people when I teach patent law, patents are like milk. They have an expiration date. And 2033 is coming fast. So they've spent 13 or 14 or 15 almost years in this dispute. And that hasn't stopped them from licensing and all of that. But the fact remains that this uncertainty has been around all that time. And soon it's not going to matter.
Yeah, absolutely. And, we're not done talking about interferences. Those were the first two, but there are 4 more CRISPR interferences involving Broad and CVC. Of these 4, 2 of them involve Sigma Aldrich and the other 2 involve ToolGen. So tell us a little bit about why ToolGen and Sigma Aldrich are involved in these interferences, because from what I understand, it's, the same subject matter as the second interference that we were just talking about.
So they're actually the 4 interferences, ToolGen versus Broad, ToolGen versus CVC, and then Sigma Aldrich individually versus either of those. If you want to know why they were instituted, I'm not sure whether they were provoked or not. I don't remember. I think Sigma probably was, because those earlier patents were being used by those CVC and Broad were being used to prevent them from getting their patent in condition for allowance. And I just happened to look up the petition that they made to the director at the time, that wasn't the way it should be handled, and ultimately prevailed. But both of them, against both Broad and CVC, are senior party. So, and they're very significant because all of a sudden, both of them should, if everything else plays out, should win because they have an earlier filing date on both of them and they get all the presumptions in their favor. Now, I think the likelihood that they win against CVC is lower than the likelihood they win against Broad because CVC has a really early date, March of 2012, earlier than anybody else. But we don't know because they went through the interferences. All four of the interferences went through that motions phase that I talked about, and the board made decisions on those motions. And then they stayed all four of those interferences, waiting for the outcome of the CVC versus Broad interference. And the reason, of course, is that one of those parties is going to win and one of those parties is going to lose. And the interferences that ToolGen and Sigma individually have against the losing party will then be vacated, quashed, dissolved. It won't exist anymore, and the board won't have to deal with them. And so whoever won, they'll have to deal with those two interferences, one against ToolGen, the other against Sigma, and then that'll go along its way. The good news is because all of the earlier priority motions are done, the board has and the parties have the same sort of limited time frame, 8, 9, 10 months, something like that, from when they start them up again to when they have to get to a final decision. Now, of course, there's always appeals and such, but the fact remains that they will get this done in the time frame of the next year or so against those two, and then we'll see what happens from there. And of course, the other thing is, either Sigma or ToolGen, who are both companies, will, when they win their interferences, rather than letting the board declare an interference against each other, will they just settle? Will they get together and figure out who should get priority and what economic and licensing provisions they're willing to give one another? And that would be, if you're in the predicting vein, I would predict companies are more likely to do that because it's just again, unrequested opinion. These guys should have done this a long time ago. It doesn't make any sense, but that's not what happened. And so I get the siren song of licensing revenue. I understand that, but I also think that this has gone on a very, very long time.
So, Kevin, given all these interferences in the rulings to date, what do you think this means for the future of CRISPR research and applications? And what do you think tech transfer offices should be most aware of?
Well, I think that it's better off to ask permission than beg forgiveness, and I think that all these parties generally tend to want to license academic researchers because there's no benefit in not. I think that they all have. I remember Worf, for example, with stem cells 20 years ago, had very generous terms letting researchers license and make sure everybody knew that. They didn't. Commercial entities are a different story, but I don't think that the actual doing the research is going to matter very much. I think that you're better off getting a license because at that. If you do, you'll just be protected. Now, who do you need the license for? Depends on what you from. I mean, it depends on what you're doing. But I think that ERS, which is the company that's licensing a lot of the California, Vienna stuff, I think they firmly believe that no matter what happens, they're unrestricted by cell type patents will be infringed by any eukaryotic CRISPR. If the Federal Circuit were to affirm, I seriously question that because I think they made a decision. They made a strategic decision to try to get eukaryotic CRISPR under their patent umbrella, and rather than relying on the genus species distinctions I made earlier, I think that if one of my clients was sued by California on CRISPR, I think that the first thing I would do is file a motion to dismiss because you'd have a determination by the patent office that they didn't invent it. And I think it's very hard to say that insofar as you have the species that are covered by their claims, at least on their face, that to enforce that against eukaryotic CRISPR, if they finally lose this interference, I don't think that would fly with most judges. I would be tempted my second filing, it'd be a Rule 11 filing, because I don't think that, I really don't think that it doesn't make any sense to do. But I certainly think that my argument would be, Judge, how can my client be liable for patent infringement over a technology that the patent office determined they didn't invent? So I think that even though, if you look at some of the things that are online and that sort of thing, their position is that they have a dominating patent, and you need a license from them. And I think that because this is the final decision from the patent office, there's nothing, right? I mean, it's the Federal Circuit is still reviewing it, so it could come down, so they would be exactly right. So they're not doing anything wrong by doing that. I just think that in a world where the Federal Circuit just throws up its hands and affirms, that will be a difficult thing for them to do.
Yeah, that will be fascinating to watch if that is, in fact, what happens. I guess we'll see here, hopefully shortly. Are there any lessons that you think innovators or researchers and maybe tech transfer offices can draw from all these interferences and use taking forward?
Well, I mean, I would say kumbaya. I mean, I think that it's better if you clear it out and not have it be this problem. I think going forward, as I said, I think that if I were a tech transfer person and I had somebody give me an invention disclosure, I would say, okay, what do you think is going to be the commercial opportunities for this? And they may be asking me that question, because if you're going to do something that needs federal regulation, right? We have one case, Merck v. Integra, that says that basic science is under the safe harbor. So I don't think that's a big problem. Although, as I said, if you have a license from either or both of Broad and CVC, then you're protected, and that's, since their academic license is not a problem. I would look carefully at those licenses to see if they have but if you commercialize sort of a clause, which they might. But then I would say, honestly, okay, if you're telling me that you're not going to get a product to market until 2035, then between the safe harbor of doing research and the regulatory safe harbor, I'm not sure that you're ever going to have a problem with these patents. Right. So I do think that it requires, you talk to outside counsel, have them look into it for you because you're busy and have other things to do. But to give you an idea of what the likelihood is that it's going to be a problem. But remember, the other thing that's happened, and as I did a little looking to see who's declaring how many patents they have, there's lots of patents out there from lots of people.
Well, there's tons, yeah.
Right, there's tons. And there's all sorts of Cas proteins now. There's all sorts of other things. I had a client who was doing something and commercializing it and not related to university. And they were getting sort of letters from one of these parties. And they said, look, if we have to, we can re-engineer what we've done using Talon or something else. And we don't want to do that, but we could. Okay. And if we do, then we're outside the scope of their patents and nobody cares. They all worked it out, so it wasn't a problem. My point is to ask, are there alternatives? If you needed to, could you? Because to a certain extent, if you have proof of concept with CRISPR, which is easy, if you can make the same genetic change, because now you've found out from your research that this is the genetic change that works, well, you can do that. I think that we're keeping the options open, I guess, is what I'm trying to say. And yet, I think you need to, especially universities, need to respect patents, because universities are getting patents and you don't want to be made to look like a hypocrite on the witness stand. And so you really want to be able to say, we looked at the situation, we complied with all the laws and rules and regulations, and here's what we did, good faith. But that's why reaching out to both CVC and Broad now, especially CVC, should be very, very receptive, because you can backload everything. You can say, okay, we'll take a license from you now. Unless you win, you don't get any money, right? Because I think that it seems to me that if they said, oh, no, you have to pay us, it's like, no. And you get a letter from outside counsel to say, we see you're asking for this. How far do you want to stretch improperly the scope of your patent, since you don't have these rights anymore as of today? And you may get them back, and then we'll have a conversation. But that's all you've asked for as a university, is to say, we're not going to give you any money on this until you prevail, or something comes out, you have maybe the two parties get together and they settle after all this is over. Unlikely. But whatever the situation is, it's very unsettled now. It's very uncertain, and it's almost unconscionable for any of these, except for Broad, because they won, to say, "Oh no, you have to pay us today," especially since you're not commercializing. That's the other thing, right? You, as I said, you have safe harbor protection, so you're not going to be doing anything that somebody could go into court and sue you for. Not yet, and you want to make sure that if you get to the point where you want to, then you have worked out the licensing arrangements and such. And also keep in mind that very strongly and clearly in any license agreement of any kind, it says, this license, that your responsibilities and obligations under this license will expire with the expiration of every patent that's under this, right?
Exactly.
Yeah.
So, Kevin, let's switch gears a little bit and turn to the patent situation in Europe. Tell us, what's the status of the Broad Institute and CVC's CRISPR-Cas9 patents over in Europe?
It's a little bit of a mess.
It's a lot of mess.
Yeah. And I say it's a mess because when I looked at this, you have a bunch of patents that were for Broad, that were revoked. And then on appeal, they came back and they were reinstituted. And it's an interesting situation with Broad that they had Professor Marafini again. When they filed, I guess Broad and Rockefeller had some collaborations, and in a provisional, or maybe more than one, Dr. Marafini was named as an inventor, and his affiliation was always with Rockefeller and I think it's not Rockefeller, and not with Broad. And so when they filed their PCT application and then went into Europe, neither Rockefeller nor Professor Marafini were named. And the Europeans are sticklers about this, very much so. But there's a reason for it, right? Because they want to make sure ab initio that the right parties are named, because you're not entitled to file an application for a patent unless you're either the inventor or you're the owner, who's gotten it by assignment, that sort of thing. And so I totally understand under their system why they want to make sure that you don't have any questions later, because EPO is essentially managing every country that's part of the EPC, right? Can rely on them to be able to get a patent that's nationalized based on the EPO examination, and that involves the formalities as well, including inventorship and ownership. And so you don't want a situation where somebody is relying on their patent in England or France or Poland or wherever, Italy, and somebody comes in and says, "Oh no, you don't have the right to this." And so I get it. But it actually caused a certain amount of a kerfuffle, because then the Broad appealed. And my understanding is that the appellate board, at least in part, overturned that determination. So the last tally I have, and again, I disclaim the validity of this only because it changes every 5 minutes, is that there were 7 patents that they had in Europe, that Broad had in Europe, not applications, actually granted patents, and 2 of them were revoked and are still revoked. Okay? CVC had 5 patents, only 1 was revoked, but then they voluntarily withdrew the other 2, or 2 of the other 4. And my understanding is the reason for that is that by doing that, the determinations that the board made against those patents, in opposition, I suppose, was insufficiency of disclosure, right? And remember that one of the arguments about them not getting meaning CVC not getting their priority in the U.S. was that the earlier applications that they filed upon were insufficient, that they hadn't reduced to practice, as a matter of fact. And so under the circumstances, they don't want any of that to come back and be used against them. So if they did that, if they withdrew, what European appeals do, as I understand it, is they give you kind of a preliminary opinion. Here's what we're going to do, right? And then they do the final opinion. So, but the preliminary opinion doesn't have force of law. It's not a final determination. It's more because they're much more collaborative in the sense that, if you go to an opposition, you can have the main request and a dozen auxiliary requests where you pare down the scope, because all they care about is making sure that you have a patent of the proper scope. And so if you as the presumptive patentee are willing to reduce the scope, they're perfectly willing to let you do that, because then that makes them happy that you've reduced the scope and you've given yourselves, as the board or the appellate board, you've given yourself some comfort that this is what they believe they're entitled to, and we think is comports with the sufficiency or novelty or event of step rules or what have you. So I think that the reason that it was done, my understanding from reading the tea leaves and reading some of the stuff online, is that CVC did not want this to become an official opinion of the European Appellate Board. Like, no. So, yes, could somebody proffer it against them? They could. But first of all, I would say, well, it's a different legal system. It's Europe. It's not United States. Their sufficiency rules and our rules on enablement written description are different. And they never made a final decision. The fact that I withdrew doesn't really matter. It's not a final decision. And final decisions can change. And we decided not to fight it. We decided just to withdraw it. It wasn't worth it. And that was our right to do. So I think that it's curious in a way. But when you look into it, it makes perfect sense that if I were them, I would really want to, grasp the nettle and keep this from being a problem for me in America and elsewhere by just giving me it's not worth it. Let's just move along, and we have other patents that we're pursuing, or other patents that have been granted. Let's just go forward.
Yeah, it seems like a really smart strategic decision. And then that leads me to ask you, what's going on with Sigma and ToolGen's patents in Europe?
Well, I think that Sigma had one that was revoked. ToolGen's patent was revoked in 2021 on procedural grounds, overturned on appeal. Okay, so it now has 3 other patents that nobody's tried to revoke yet. So it has 4, as I said. One had been revoked previously, and then the appellate board overturned that on appeal.
Yeah, so it's quite the mess, as you said, over there. And so then, given that this is really a hornet's nest there, who has the dominant position for CRISPR-Cas9 in Europe?
I would say we don't know. I said before, talk to Broad. If you want to work in Europe, talk to Broad and CVC, talk to ToolGen and Sigma too. Right? I think you need to at least reach out, and also that requires that and again, this would be European Outside Council, but it would require you to say what you always say. What do you want to do? What's your technology? What CRISPR did you use? What Cas did you use, et cetera? And then really look carefully with the granted patents in Europe to say, who do you infringe? Because it's possible that these are different enough that you would infringe one party and not another. And if that's the case, if it's clearly the case, then don't waste time licensing something you don't have to license. But I do think that this is one of those situations in patent law that it's so complicated. There's so many parties, and this is the tip of the iceberg. That you're much better off. Just being careful and doing the analysis yourself before somebody else sends you a letter where they did the analysis that's in their favor. At least if they do that, then you'll have the rebuttal already done, and you won't have everybody getting upset that they've been threatened, because you will have anticipated what they could say. And to the extent they say what they could say, you'll know what to do. And to the extent they say something you didn't anticipate because a new patent came out, well, you'll deal with that problem when it arises.
So, Kevin, I want to turn and ask you about 2 more jurisdictions, Japan and China. What's the status of Broad's and CVC's patents in those jurisdictions?
Well, I think I told you that one of the ToolGen didn't invalidate one of the CVC patents. The numbers on there are both the Broad, CVC, and ToolGen each have 3. Sigma has 1 in China, and Broad, as you might imagine, has more in Japan, has 8, and CVC and ToolGen has 3, and Sigma has 1. And again, that's just when I looked. The last time I looked, who knows what happened yesterday? But yeah, that's kind of they have a smaller number, which I think has a lot to do with the way the patent systems in those countries work. And remember, Broad's had a head start. Broad has over 30 in the applications or patents in the U.S. So, they've always been very aggressive with that.
Very, very aggressive. So Going to be interesting to watch there, as well as I'm sure many other jurisdictions that we didn't have a chance to touch on today. But Kevin, as the podcast comes to a close, any final thoughts you think tech transfer offices should take away from all these disputes involving Broad and CVC's patents over these CRISPR-Cas9 technology?
Well, I think that you have to realize that it's a moving target. Because, as I said, it's been so long, so many years since the original, that there have been a great many new things that have happened in the science, and different Cas, or not even Cas-like proteins, that you have other types of genetic interferences or interference that is done, or modifications that are done. You have Cas using as a nick-ACE, that sort of thing, to do much smaller genetic scissoring. This is always the way people analogized it. That because of that, it really depend on every time you get a new disclosure from a scientist in your group, then it really requires you to look at it with fresh eyes. There's nothing this is the standard way we do this, because you can expect that you'll have this sort of thing come up, that people will have new ways of applying CRISPR to new things, that it'll be a question mark. The only other two things that I wanted to mention was that the University of Missouri has gotten the first CRISPR pig patent in Europe. So this is somebody that, come out of nowhere. They have a CRISPR modified pig. I don't know how they modified it, but that's one thing. And then the other thing, just on the downside, is there's a proposed ban in Europe on selling CRISPR genetically modified plants. It hasn't been passed yet, but it's being considered. So, I think that the lesson that we all learned in Myriad, not to cause anybody to have, flashbacks, was that we can't pretend that we're, out here on this patent island and not have to deal with the rest of the world. And so, I don't care how great your CRISPR is. If Europe says you can't sell CRISPR modified corn, that's a big deal. Now, I'm not saying there's any way to fix that, but I'm saying that you should be aware of it. And certainly, if I were writing a license, I would want to put in a clause that would say that anything that would be owed to Broad as a license, or CV as a license, is subject to any regulatory or governmental prohibitions. And they'll probably think that means CRISPR modified kids, but if you make it broad enough, you can get things other than that. And so I think that I think it's also, well, the other thing, I was giving a talk on CRISPR in Boston a couple of months ago, and when I looked into the way that sickle cell anemia is being addressed, at least one of the ways has nothing to, actually I don't think either one of the ways has anything to do with actually fixing the defect. What it does is it enables the cells to make more of the fetal version of beta globin, which may be gamma, but the fetal version of it, so that they essentially just replenish the stem cells that are now not making adult beta that has the mutation. They're making fetal beta, and that at least alleviates enough the symptoms of the disorder. So, yeah, it's funny, because I think that we need to realize that even though we've had all of this patent kerfuffle going on, we've had all of these things, this is a advancing technology. This is something that's not really at its end yet. All sorts of ways to apply it, and that means that as people do that, there'll be patents on those as well. So that's why I think you really need to keep your eye on the ball in terms of who's out there getting patents on what, and also when you look at what your scientists are doing, make sure that they explain to you as fully as they can how what they've done is different. And if it's just the same old technology, no offense, that's being applied to a different cell type or a different organism, that's one thing. But if they've really made modifications and differences, there's nothing to keep. If they really did make that modification themselves, there's nothing to keep, as the University of Missouri got a pig patent with CRISPR, and nothing to keep any of the tech transfer offices here or anywhere else from getting protection for the new CRISPR, right? The new and improved CRISPR, and applications of it to be able to do all the things that we have that we've hoped to be able to be done from the beginning. It's a great technology. It's just, as with anything else, it's technology. It has to be adapted and modified and improved.
Kevin, thank you so much. This has been fantastic having you on the podcast today. And thank you so much again for getting us up to speed on what's happening with these Broad and CVC patents.
Great. Happy to do it. It was a lot of fun. If any of your listeners have any questions, my email is noonan@mbhb.com. Don't be shy. I do take emails from folks to talk about this stuff and be happy to do that because it's complicated. And I think that it benefits me to hear questions that people have as well, because then I get to think about what your questions are, and that may make me think other things, which is always a good thing.
Absolutely. Thanks so much again, Kevin.
Sure. Thanks. Have a good day.
Thank you, Kevin, for providing such detailed explanations and insights into the ongoing disputes between the Broad Institute, CVC, as well as others on CRISPR-Cas9. To our listeners, we hope you enjoyed our discussion with Kevin as we unpack the complexity of CRISPR technology, its revolutionary potential, and the complex patent landscape surrounding it. Please join us next week where we continue to explore the intersection of technology, innovation, and technology transfer.
Thanks for listening to Autumn on the Air with Lisa Mueller. Get social with us and share your thoughts. You can tweet us at AUTM or visit us online at autm.net. We'll be back next week on the air. Be sure to join us.